So we've all been yelling internet censorship. Now the Supreme Court is finally taking up a case that's challenging 230. Let's check it out. All right, so for the first time, the Supreme Court's going to take up a case involving Section 230 and the limits of Section 230 on internet companies. So here's a little background on Section 230. So now in 1996, the Communication Decency Act was passed, and it's known as Section 230. And it was intended to protect free speech on the internet by shielding internet companies from liability for much of the content their users post on their platforms. Now, it's interesting to note this is known as the platform versus publisher distinction within the law. See, if the company was a platform, they are essentially saying we're like a billboard, and anybody who posts stuff on our billboard, we're not responsible for what they post. We're just simply a place where people can post things and they're responsible for what they post. So let's say if they were to post something defamatory on the platform, then the platform wouldn't be responsible. It's the person who made the post, and whoever wants to sue for something like defamation or slander, they would be able to sue the person who made the original post, but the platform would be immune. That's what Section 230 did. Now, that's different if you're a publisher. That's something like the New York Times or the Washington Post. They actually control what content they put out. They have editors and people who read the content and say, this is the type of content we're going to put out on our site, right? And not anyone can just post anything there. So that's what makes them publishers. And as a publisher, if they say something defamatory, the New York Times or the Washington Post, they will be responsible for that content. So where someone like Twitter considers themselves to be a platform and they can more or less, anybody can say whatever they want and they wouldn't be held responsible, the New York Times would be considered a publisher. And if they allow someone to say something in their newspaper, then they could be held responsible for those words. So that's essentially what Section 230 did. But as with all good things, something went wrong. Now, the issue that's come up is that Section 230 has just become such a big monster when it comes to online speech, where now essentially the platforms can curtail speech, they can stop speech, they can censor speech, all under 230 and have no repercussions. So now pretty much lawmakers on both sides are saying, well, hey, we need to trim this down a little bit, because right now Facebook, Twitter, and all of these social media companies have this broad authority to essentially censor speech and still claim to be a platform. And that's what this case essentially is about. Where is the line when a platform crosses over to becoming a publisher and losing that 230 protection? Gonzalez, a 23-year-old U.S. citizen, was killed in an ISIS attack in Paris in 2015. Her family actually sued Google, alleging that it was partly responsible because it promoted videos and other content from ISIS. And the question in this case was whether Google was entitled to 230 protections when it recommended content to others, even when that process is handled by algorithms. So the plaintiff's argument here is simple. If Google was a platform, then they wouldn't be promoting any content to anybody, right? You just go to Google, you see something and you like it, you can promote it. But soon as Google now writes this algorithm and it promotes content to certain users, it says, like for instance, I like football. So if I click on a football video, the algorithm is going to send me more football videos. And in that case, if you like ISIS and you click an ISIS video, the algorithm is going to send you more ISIS videos. So they're saying that makes Google more of a publisher than a platform, because they are actually directing people to say, hey, watch this content. And that if that content is, illegal content, if it's defamatory content, if it's anything like that, then Google itself should be responsible, because at that point, they're not acting as a platform, they're acting as a publisher, trying to get people to watch particular content under their recommendations. Now, the Ninth Circuit Court of Appeals ruled that Section 230 protects companies from lawsuits, but also raised concerns within the law. Now, the case Gonzalez v. Google appeared designed to catch the attention of Associate Justice Clarence Thomas, who has questioned 230 in other contexts. Now, this comes off the heels after the Supreme Court dismissed as moot another high-profile case last year involving former President Donald Trump, when he was blocked by several social media companies, Twitter included. And Justice Thomas really kind of laid into the power that social media companies have and how they're treated differently under this specific law. Justice Thomas says, much like with communications utilities, this concentration gives some digital platforms enormous control over speech, Thomas wrote. When a user does not already know exactly where to find something on the internet, and users rarely do, Google is the gatekeeper between the user and the speech of others 90% of the time. So with this case, Gonzalez v. Google in particular, it comes down to the fact of when is a social media company acting as a publisher and not a platform. Now, this argument has actually recently been made in the Texas case in the Fifth Circuit, where the Fifth Circuit said the Texas law regulating social media companies in Texas could go forward. And the catch-22 is this. If the social media companies, if they want to say their platforms, then this heavy-handed approach to content moderation shouldn't really be allowed, in the sense of, yes, you can stop things that are illegal, you can stop things that, but you really can't stop things that are uncomfortable for other people, right? Hurt feelings shouldn't be enough to ban people off the site. But a lot of the social media companies have these kind of internal controls to say, hey, we just don't want that speech on our platform, and remove it. So with that type of control, does that now make them a publisher? If Twitter says, hey, we don't want any more LGBTQ speech on our platform, and then ban everyone who says things like that, does that now make them a publisher because they've stopped that particular speech on that platform? Now, Twitter would say no. Twitter would say what they're a private company, and as a private company, they can say what's on our platform and what's not on our platform, and that's one of the powers that they have being a private citizen. They're not the government, right? The government has to give you free speech, not the private corporations. But then on the other side, you have to kind of admit that if you're determining what I can see and what I can't see, right? That is inherently publishing, right? If you're saying I can see this content, but you can't see that content, that's inherently publishing. So essentially, where is the fine line? And now I think that line is so muddy that really the social media companies have essentially been taking advantage of this platform versus publisher distinction and just saying everything. We're platforms in all sense of the word, even if they are publishing and moderating content themselves. So we'll see, but the way the Supreme Court is now and the power of social media, we'll see if the Supreme Court changes its way of thinking when it comes to 230, and whether these social media companies would still be allowed to act in this way and have these same legal protections as they've had for multiple years. It seems like the court's ready to step in and limit them, but again, we'll see, because again, I don't know if this case is going to be successful or not, but it is going to the heart of the matter, right? How much or how far do these protections in the 230 go? And the fact that the Supreme Court is taking it up shows you that there is some contention on whether this is going to move forward. But let me know what you think in the comment section. Do you think Section 230 should be left alone as it is? It's one of those mind-blowing things that both Democrats and Republicans both agree that there need to be changes within Section 230. Now, I know there's a lot of people who are on the right who says it's all, every time it's censorship is against the right. And then you have the left, where everyone says the censorship is all against the left. For instance, here are two examples that I'm going to just leave you with. One example was PragerU. PragerU sued YouTube because YouTube demonetized them, and essentially used the same thing. Hey, we're conservatives, this, and you just don't like our conservative thought. That's why you demonetized us. YouTube won that suit under Section 230. We're not publishers. We're a platform. Your suit is dismissed. And that was extremely right-wing, and a lot of right-wingers would bring that up as an example, PragerU. But then there's another example on the left where some LGBTQ plus advocates actually sued YouTube because YouTube demonetized their content also. And guess what their claim was? Hey, you're censoring us, under this 230 thing, and their claims again were dismissed because of Section 230. They said, well, hey, we can do this to you because, again, we're just a platform, not a publisher, and our rules say you can't put that type of content up. Now, obviously, YouTube has changed its policies after that case, but in those two cases, one on the extreme right and one on the extreme left, you still had the same thing, where Section 230 was used as a shield to stop both of those suits from moving forward. So hopefully we'll see where it goes. But as of right now, Section 230, I believe personally, needs to be limited, but what makes sense is where we go from here. So let me know in the comment section how you think this case should go. And my name is Nate the Lawyer, and I'm out of here. Peace.